welcome tonight. Tonight's talk is about whether or not speech can be compelled and what, if any, protections the First Amendment offers against compelled speech. For those who value free inquiry, it's a subject of some importance. Tonight's talk is sponsored by the George Washington Forum, a civic education initiative, which aims not just to promote viewpoint diversity here at OU, but also to provide a forum where sometimes contentious subjects can be discussed and debated in a reasoned and reasonable way. Tonight's event, like all Washington Forum events, is not made possible by public funds or your student fees, but by donations of OU staff, alumni, and grants from foundations, including in this instance, a grant from the Thomas W. Smith Foundation and from the Jack Miller Center. And I want to thank both of them for helping bring William Messenger back to Athens. I say back to Athens because Messenger is a 1997 graduate of Ohio University. He received his B.B.A. from here before earning a J.D. from George Washington University in 2001. From there, he went straight to the National Right to Work Legal Defense Foundation, where he has litigated nearly 100 cases, including over a dozen at the U.S. Appellate-level. Many of his cases have defended workers' freedom from compulsory unionism. He has, for instance, recently challenged the Seattle ordinance designed to force ride-sharing drivers into compulsory unionism, and that case is currently before the U.S. Ninth Circuit Court of Appeals. His legal work is also focused on the First Amendment, most of which focused on free speech issues. And he's argued 3 successful cases before the United States Supreme Court. In 2014, he argued Harris v. Quinn, securing a ruling that requiring home care providers to pay union fees violated the First Amendment. And 4 years later, he also briefed and successfully argued Janus v. AFSCME, in which the Supreme Court ruled that non-union government workers cannot be required to pay union fees as a condition of employment. I think it's fair to say that Messenger's advocacy for Mark Janus and the Supreme Court's decision, which resulted in Janus v. AFSCME, hasn't pleased everyone. But in their Supreme Court arguments, Messenger, representing Janus, and the attorneys opposing him, who represented AFSCME, had to deploy reasoned arguments and evidence to convince the justices of the merits of their arguments. Reasonable minds could and did disagree about the merits of those arguments, as evidenced in the court's 5-4 decision in favor of Janus. But the point is that reason was the currency of realm in the courts of law, and so it is here tonight in Galbraith Chapel. The forum, to put it another way, is about civil debate, not about activism. It aims not to persuade people to adopt one position or to another, but to bring voices to campus not always heard here, and to model to what reason and reasonable debate looks like. There'll be plenty of time for questions and answers after Messenger's talk, and he'll be glad to answer your questions. But to ensure that tonight's event can produce a rigorous yet civil dialogue, I'll simply reiterate the obvious. The university seeks to provide opportunities for learning and the free exchange of ideas, including events such as this one. In the interest of ensuring an orderly event, audience members are asked to refrain from engaging in conduct that would disrupt the event. Anyone engaging in disruptive behavior will be subject to removal. To put this in even another way, the Washington Forum embraces intellectual agonism, but agonism of a reasoned and civil sort. And so I hope you'll join with me in welcoming back to Athens a genial agonist, Bill Messenger, class of 1997. Welcome, Bill.
Thank you, Robert, and to the George Washington Forum for having me back in Athens. And it's been incredible to finally be back and be able to wander around campus. And the main thing I kept thinking about is the old adage that youth is wasted on the young. I very much encourage you not to waste your time here because it's special. And you can always visit, but you can never really come back. But nevertheless, it's very good to be back here in Athens. And tonight's topic is free speech in the First Amendment. And it's somewhat interesting. You know, almost everyone knows the right of free speech exists. Children who can't name the 3 branches of government can tell you, I have the right to speak. Which is always sort of interesting as a parent, the first time your kid actually, that conception comes into their mind. However, the idea of the First Amendment and exactly how it works and what it says often isn't discussed. I don't remember really it being taught in civics class in high school. It's not really directly taught in college, and it's not until you get to law school that all of a sudden you start diving into exactly what's in the First Amendment and some of the different aspects of it. And so what I want to do today is not necessarily talk about compelled speech, but really just talk about the First Amendment in general and touch on a number of issues that come up with respect to free speech, and hopefully create a dialogue for after I'm done speaking to answer questions you may have about the First Amendment and to create a dialogue on that. And what I want to touch upon is first, what does the First Amendment say? What's actually in it? The second is what is speech, which is actually a very more complicated issue than you may assume. And then how can you violate the First Amendment? What are violations of free speech? And so as we should, the first place to start with the First Amendment is its text. And the text is, at least in terms of the free speech clause, is Congress shall make no law abridging the freedom of speech. Now, the first most interesting thing about that is it doesn't say you have the right to free speech. It says Congress shall make no law. When the First Amendment was originally ratified, it only applied to the federal government. That's it. So after the First Amendment was passed, if the state of New York wanted to say, thou shalt not criticize the Whig Party, the First Amendment would do nothing for you. It didn't protect you against the states. It wasn't until the 1860s and 1870s that your First Amendment free speech rights were extended to the states. And that was through incorporation under the 14th Amendment and through a federal statute called 1983 that's still on the books to this day. But that brings up sort of one of the first points I want to bring up, sort of thinking about the First Amendment, is that to this day, it only protects against state action. Like a lot of times you'll hear, like say what's in the news, the NFL infringed on Colin Kaepernick's right by retaliating against him allegedly for his protest. Or Google and Facebook are retaliating and violating people's First Amendment rights by supposedly restricting conservative speech. That's actually impossible. A private actor cannot violate the First Amendment. Only the government can violate your First Amendment right, or someone acting with governmental authority. But you actually have no First Amendment rights whatsoever vis-a-vis other private parties, or when you eventually are employed, many of you by private companies, a right to speak against your employer. The First Amendment only protects you from the government. Now, there's more in the First Amendment than just free speech. There's other parts of it that are related to speech. One, of course, the First Amendment prohibits establishment of religion, but that's somewhat of a side issue. But in terms of other things related to speech, the First Amendment provides, shall not abridge the freedom of speech, or the press, or the right of people to peaceably assemble, or the right to petition government for a redress of grievances. Now, those other three don't come up much, but they're all very much interwoven with the freedom of speech. The right to the free press is one of them. Obviously, the press is sort of a manifestation of speech. The courts, however, interpreted freedom of press basically not to give the press any special rights that you and I don't all enjoy just as citizens. Saying that you're a member of the press doesn't give you special free speech rights, but the press is so important, it's mentioned in the First Amendment. The right to peaceably assemble, much as like when you walked in here today. You saw a right of peaceable assembly outside. And of course, because you can't really exercise your speech rights if you can't come together with like-minded people and speak to that. If the government could clear the square, it very much would infringe upon the freedoms that we all take for granted. And the last one is to petition government for a redress of grievances. That basically means to speak to the government and try to influence it. And there's another word for that we use in more modern times, and that's lobbying. The First Amendment literally protects lobbying. And that's somewhat interesting because in today's age, lobbying is often thought of as a dirty thing. Or a lobbyist is sort of like a dark, shadowy character lurking in Congress somewhere. To lobby the government sort of implies a wrongful or undue influence. But to lobby the government is a fundamental right protected by the First Amendment just as much as free speech. And that actually makes a whole lot of sense. How could you have a free and responsive government if the people weren't there or weren't able to try to influence the government, as they saw fit? So next time you hear about lobbying, being talked about in the press in sort of a bad way, perhaps think of, well, is that really such a bad thing? Isn't that something protected by the First Amendment? And then the final thing to mention what's in the First Amendment is something that's actually not expressly there that most people think is, and that's the right to free association. Most people would think, I have the right to associate. I can choose who I associate with. I could be a member of the Green Party, Republican Party, Democratic Party, protected by the First Amendment. That's actually not expressly there. There is no right to association expressly there. However, the courts have implied it as being implicit with the other types of freedom. That the idea of freedom of speech necessarily encompasses the right to associate with like-minded speakers, because the government could very much control speech if it said, sure, you can shout anything you want by yourself, but you can't band together with other like-minded people to speak or to petition the government. So the right to association is just as protected by the First Amendment, but it's actually not expressly in there. And so those are what's actually in the First Amendment. And one of the biggest issues that comes up in sort of the next question I want to address is, what is speech? Because actually a lot of the litigation since the First Amendment came out really turns on that issue. Now, the first and most obvious thing is the spoken or written word. That's obviously speech. You're literally speaking, or you're literally writing a word on a piece of paper. But where it becomes more complicated is, what about expressive speech? What about art? You know, if you draw a painting, is that protected by the First Amendment? What about a political cartoon? You would think protected by the First Amendment. But then how exactly far does that go? Like many of you probably took an art class, and if I remember right, the beginning of art classes, what is art? And you basically have this philosophical discussion, and by the time you're done, every rock on the ground is art in some way, if that's what somebody wants to call it. And for those of you who've been to modern art museums, it's sometimes not too far away from that. But free speech under the First Amendment can't necessarily go that far. Like, for example, architecture is certainly expressive, how you design a building. But certainly all architecture can't be protected by the First Amendment. You know, if you wanted to build a house that looked like an inverted pyramid, and the housing inspector came by and says, that doesn't look safe, you can't say I have a First Amendment right to do that. That's how I want to express myself, my inverted pyramid house. So exactly where that ends is a contentious issue. And actually, this was one of the biggest issues of the last Supreme Court cycle. Many of you may remember the Masterpiece Cake case. And the issue in that case was a Colorado baker, a Christian, refused to bake a cake, wedding cake, for a homosexual couple. Now, most of the media scrutiny was around the discrimination versus First Amendment issue. But from a purely First Amendment standpoint, that wasn't the big question. Since when was baking a cake protected by the First Amendment? And a lot of the briefing in that case went into, is making a wedding cake protected by the First Amendment? And the briefs were, the lines they drew were incredible. The US government argued, well, if you just manufacture cakes as a commercial matter, you just got them coming off the assembly line at Hostess, that's not speech. On the other hand, if it's artistic, if you're making a cake as an artisan, that's speech. And so it gives you an idea of how thin the line is between where speech begins and where just everything else ends. You can see just arguing over cakes. And that division between cakes rolling off an assembly line versus artistic cakes brings up another issue. What about commercial speech? A great deal of the speech you see is commercial. A company trying to sell you something. You know, when you're watching television, that's what they're trying to do. Well, that's speech, right? I mean, it's literally spoken words, or it's words on a piece of paper. Somebody's doing something. Why does the content of that speech, why does the commercial nature make it protected or unprotected? And to this day, the court struggles with that. In the past, the court has basically said if it's commercial speech, it's sort of a lesser standard. It's easier to get away with infringing on it. But there's a lot of tension, a lot of fights going on right now of, is that true? Does the same First Amendment scrutiny apply to regulating commercial speech? And there's arguments on both sides. If you say commercial speech is fully protected by the First Amendment, you have a lot of regulatory state issues. Like, for example, since when can the government tell you how you have to put nutrition labels on your product that you're selling? You know, that's speech. Is that wrongful? Does that have to satisfy strict amendment scrutiny? Seems a little much, but on the other hand, where do you draw the line? At the end of the day, it is speech. And just sort of give an example of this. Imagine you're printing out a flyer, and the flyer says, impeach the president. I think we would all agree that's speech protected by the First Amendment. But let's say you printed out a flyer that said, buy cheeseburgers, $4.99 each. Is that speech? There may be reasonable disagreements over that. Let's say you changed the flyer a little bit more and it said, buy hamburgers, $4.99 a pound, proceeds to be used to impeach the president. Well, now how does that work? You know, you're literally using commercial advertising to raise money for the purposes of something, a political speech, which is certainly protected. And I don't necessarily have an answer to this, but again, just thinking through some of the First Amendment issues that are out there that may not necessarily, you know, be apparent. And that example brings to the next issue. Is money speech? And that issue comes up a lot. You'll hear it a lot from some politicians, from the media. Money isn't speech. You know, the First Amendment should not protect the ability of people to spend money. Ironically enough, sometimes this comes from people who work for organizations that literally their business is to spend money to propagate and disseminate speech. That being, of course, media corporations. And on this, actually, I think there is a more definitive answer. And that, of course, money is speech when it's used for that purpose. You know, without being able to spend money, you couldn't disseminate and create most speech. Without money, basically, sure, you could stand on the street corner and yell at the top of your lungs. You couldn't print a flyer. That piece of paper costs money. Whatever you wrote it with costs money. If you photocopy it, that costs money. And in the big scheme of things, if you're Fox News or CNN, you are spending massive amounts of money to propagate and put out that message. And for that reason, since at least the 1970s, if not before, the courts have consistently recognized that spending money on speech is itself protected by the First Amendment, and the government can't infringe on it, which brings into the campaign finance cases you may hear talked a lot about in the press and among the politicians of whether or not you can restrict, the government can restrict the spending of money for speech. But as you think about it, it becomes really difficult to justify the idea that, oh yeah, the government control how you spend money on speech. And just a simple example, imagine if the government did prohibit it. If the government said, passed a law, no one shall spend any money on speech critical of the president. No one in this room would say, no problem with that. People are still free to speak. That would be a violation. There's no reason why that same principle doesn't necessarily apply to other spending for speech. Which brings into one of the last issues, it's sort of an idea or a big controversy about speech. What about corporations? You were talking about commercial speech. What about if the speaker, instead of a person printing out a flyer, is a company? Is that protected by the First Amendment? And there's a lot of controversy over that. The big case, and many of you may have heard the name thrown around, is Citizens United. Some individuals, some politicians really don't like Citizens United. It's like a four-letter word of the idea of this horrible decision that said that corporations have free speech rights. I don't think that's really a fair characterization of what Citizens United held and whether corporations do in fact have speech rights. They don't have speech rights necessarily as a person. Yes, as a legal fiction, corporations are persons, but that's not really what the court held in Citizens United. Rather, a corporation is an association. Like we talked earlier, the First Amendment protects the right to associate. And so why is it that if you have an association, you have the right to speak, and that association's rights come from the individual member rights? So for example, the protesters outside today, most of which I would guess are probably members of unions. That's where they were here. They don't like certain things that I've argued in the past. But the union's rights as an organization to speak are derived from its members. So if Congress tried to pass a law saying unions cannot speak, the union can sue and say, no, that infringes on the union's free speech rights. By the union, what they mean is the rights of its members as an association. And so that brings the question up of, if it's an association has the right to speak to its members, why does incorporating change that? Well, let's take, for example, let's say you're an environmental group. You decide to form, I don't know, the Association to Save the Trees. 100 people get together, put together the Association to Save the Trees, do what they can to promote environmental causes. Then after a while, they look at, for tax reasons, liability reasons, a bunch of things. They say, you know what? Let's incorporate. Let's become the Association to Save the Trees Incorporated. What's changed from the First Amendment perspective? Why all of a sudden does that organization suddenly lose its free speech rights? And what they held in Citizens United is, if other associations have the right to free speech, incorporating doesn't strip those rights away. And it's for that reason that the government can't restrict the rights of corporations and of unions to spend money on political speech. Because that's what the case was about. Federal law said corporations and unions couldn't spend money to basically criticize candidates. It's called express advocacy. And the court in the past upheld that. In Citizens United, they reversed that and said, no, the government cannot infringe upon the rights of these associations just because they're incorporated either as for-profit corporations or incorporated as labor unions. Now, reasonable minds can disagree on that. The argument against that is incorporation gives certain state advantages that other speakers don't have, and therefore, if the government gives you advantages, it can take it away. So to be fair, that's the argument. But really, not even Citizens United, not even the dissent, said the corporations don't have any free speech rights. They were more saying the government has more of an interest in infringing upon them. So that's the corporate speech idea, which you may hear bandied around a lot. And then the final topic I want to address is, when can you violate First Amendment rights? What is an infringement on First Amendment rights? Now, the most obvious is a restriction. The government says you can't say that. That's obvious. That's an infringement. Now, First Amendment rights aren't absolute. The government can infringe on your First Amendment rights if it satisfies a high level of scrutiny. Usually it's what's called strict scrutiny. The government cannot infringe on your right unless it has a compelling government interest and there's no better way to do it, to oversimplify it. Usually in most circumstances. Generally, that test is very difficult to satisfy, but it's not impossible. The right of free speech is not absolute. But what's more interesting, and something that I've dealt with more personally, is what about compelled speech? Can the government force you to say something that you don't want to say? And the courts have recognized, no, it can't. And this makes sense, because the right to speak, whenever you're formulating what you're saying, you're not only picking what you're saying, you're picking what you're not saying, any content. If you write a book, you're picking what you write in the book, what you're not. As I'm sitting up here talking today, I'm thinking not only what am I saying, hopefully, and also what am I trying not to say, to stay out of trouble. And so the right to speak and not to speak, are coextensive with one another. And for the government to compel someone to speak is a violation. And in fact, in Janus, the Supreme Court held it was actually a worse infringement on First Amendment rights in terms of the interests it protects than a restriction, because there's almost nothing more demeaning than compelled speech. Like, imagine, which would you think is worse? If the government said, on Tuesday, you're not allowed to stand in the square over there and criticize the president. Or if the government said, tomorrow you have to stand on the square and tell everyone why you think the president is the greatest person you've ever heard. I would say the second would be the worst. Compelling you to say something you don't actually believe against your will would even be worse than a restriction. Now, restriction's not good, but compelled speech is even worse. And this has long been recognized. The old case, West Virginia versus Barnett, they said you couldn't force a student to say the Pledge of Allegiance in class. This is back in the 50s, even during the height of the communist scare. That violated the First Amendment because that was such a core speech right. But where there has been a lot more of a fight, what about compelled association and compelled subsidization of speech? And that actually has been a lot more of a difficult fight, and that fight continues to this day. The first issue, this one would sound obvious. Can the government force you to support a political party? Can the government say, you have to join the Republican Party and give it money? Or the Democratic Party, whatever, doesn't matter. You pick it. You would think, of course not. That's obvious. Well, up until 1977, in a Supreme Court case called Elrod, the courts, or the government could if you were a public employee. And in fact, if you go through the history of what happened, maybe some of you may remember the spoil system, back in the 1800s. If you wanted to work for the Andrew Jackson administration, you better be a member of his party. The first thing he did come in the office is clean out every employee there who wasn't a member of his party. If you wanted to work there, you better be a Jacksonian Democrat or you're out the door. That was actually constitutional, at least the court held it was, until 1977 when the court in Elrod said, no, you can't do that. You cannot force somebody to actually be a member of a political party to keep your job with the government. Now, some people still think that's wrong. The originalists on the court would say, hey, that's the way it was back in the day when the First Amendment was ratified, arguably. Therefore, that should still be permissible today, but right now the court majority, no more political patronage. But the second issue that comes up in that, and the one that actually has been what I've been litigating for the last 19 years, is what about compulsory support for a public sector union? So starting right in the late 1960s, public sector employees started to be unionized. And what that meant is the government would say, for purposes of dealing with the government, this union is now your representative. This union will now advocate for you before the government and try to influence government policy. In a good way too, get you more money from the government, better terms and conditions of employment, what have you. Now, that's core political speech. The function of a public sector union is literally to petition the government for a redress of grievances. It is a political association. So a case was brought called Abood that argued that very point. If you can't force us to support a political party, how can you force people to support an advocacy organization, which is what a union is? But in Abood, the Supreme Court said, that's fine. That's actually constitutional. You can force someone to support a public sector union as a condition of keeping your job, even though it was very similar to a political party. Litigation went on about that for the next 40 years until the Janus decision, which I had the fortune to argue on behalf of Mark Janus, in which they overruled Abood. And they said, no, the union's job as a political advocacy organization makes its speech political. Under the First Amendment, you cannot compel a person to support that speech as a condition of keeping their job. Now, of course, an individual is free to join and support that speech if they want, but you can't be forced to do it. And this decision was controversial, at least in two ways. One is just in terms of the practical effect. Prior to Janus, our calculation is well over 5 million public sector employees were required to pay union dues to keep their job. You didn't have a choice. So if you wanted to be a public, say, state employee in Ohio, public school teacher, you had to pay about $1,000 a year to a union or you were fired. And there were roughly 5 million employees in the country who didn't have that choice. So just in terms of numbers, it was somewhat of a big deal. But it's also controversial in that many disagree, with that decision. And to try to be fair, I'll give the alternative argument. The alternative argument of why that should be okay is the union represents everyone. The union speech, its bargaining with the government, helps everyone. And therefore, if you don't pay for it, you're a freeloader or a free rider. How is it fair that the union helps out everyone, and yet you're taking the benefit of the deal and you're not paying for it, and your coworkers are? That was the free rider argument they relied upon in Abood, but that they ultimately rejected in Janus. Now, it's something to think about, draw your own opinions. I think it doesn't hold water because the whole idea of the First Amendment is you get to choose what speech is in your best interest. The government doesn't get to say, you know what, this advocacy group, its speech is in your best interest. That's who you should support, whether you like it or not. We know better than you. Rather, it's up to each individual to decide whose speech, is in their best interest and to choose to fund that, if they want to or if they don't. So that was the counter argument. That's what the Supreme Court accepted in Janus. But of course, to this day, reasonable minds, may differ. And then the last instance of compelled association is there's one last group that can be forced to pay and support a group against their will, whether they like it or not. Lawyers. In many states, lawyers are required to support state bar associations, whether they like to or not, which is sort of ironic that, the people dealing with the courts are now one of the last bastions, of compelled association, in this nation. But right now, there's a number of cases pending nationwide, working their way up to the Supreme Court. I wouldn't be surprised if you saw the court take one of those sometime in the future. So that's compelled speech and association. And so in a nutshell, that's just sort of an overview, at least what I see, of some of the more controversial issues out there that are dealing with the First Amendment. And what's in the First Amendment, what is speech, what are the different infringements on speech. And with just sort of touching on a number of those issues, what I'd really like to do is open up the floor and see what those of you, may have questions about or what you might like to talk about. Yes, sir.
I was wondering if you could give some insight into, as we move forward in sort of digital media, how the courts could adjudicate different legal principles that might be in conflict. So, for example, you have the principle that if you have a public carrier, people can't be denied access to that, right? So,
yes.
Telephones being one of the primary cases, but people could argue that the internet, right, internet providers or sort of monopolies like Google are in effect public carriers, and that to be deplatformed from that is essentially even more of a loss to your substantive rights than being denied a landline phone line, right?
Sure.
So how would the courts moving forward with these issues sort of deal with that in your view?
I think there's two very good questions there. So the first is, when he's speaking of monopolies in the past, there's a doctrine which actually hasn't been overruled yet. It's called the Red Lion case. And before the internet, which many of you probably don't even remember, the amount of bandwidth out there was very limited. The radio spectrum was only so big. There were only so many TV stations that could be carried. And the government took the position of, well, because there's only so much bandwidth, we can control who uses it and we can regulate that. And that's why the government was able to regulate a lot of content on what was network television. You couldn't have profanity, you couldn't have nudity. And the way the government got away with that under the First Amendment was there's only so much of this. And because there's only so much of this, we can divvy it out and put conditions on how you use it. But does that still apply today now that at least in terms of the internet, there's not unlimited bandwidth, that's of course not true, but in terms of realistically how many channels you can pump through, anything, how much you could put on the internet, that argument falls away. So how can the government, as the Federal Communications Commission, how can it constitutionally justify any content restrictions on what you can do? Before, there was what's called the Fairness Doctrine, where the government would literally require that if you gave so much time to one side, you had to give so much time to the other side, regulating what the media would do. They dropped that before it was declared unconstitutional. That gives you an idea of what they used with the idea there's only so much bandwidth. Red line is still the law, even though a lot of people say it's dead man walking. That eventually, when the government does impose a restriction, it won't be able to survive because that justification for it is gone. And then I think the second question that was in there is, when you have Google and some of these other companies that have a huge amount of market share, I forget how much search goes through Google, but it's a very high percentage, or how much social media is through Facebook, et cetera. They have close to monopoly positions. How does the First Amendment apply there? I think the First Amendment still doesn't. The First Amendment at the end of the day requires state action. And so no matter how big of a monopoly Google is, it's not the government. And so I don't see, at least personally, what the First Amendment angle is there. However, the statutory angle is huge. You have antitrust laws. And so, if and when Google does reach the idea of monopoly, or Facebook, then as a matter of statutory law, you can see the government step in and say, no, you now have a fairness doctrine, so to speak, with respect on your Google searches, or how Facebook puts out things. And then in turn, guess who's going to use the First Amendment? Because now you do have state action. Google and Facebook. They're going to say, trying to regulate us that way violates our First Amendment rights as a corporation. And then you have that very fight, back to red line, of do they have enough market share that you can in fact justify? It hasn't reached the courts yet, at least to my understanding. It could, hate to say, disprove a negative, but it very much is a very large issue you'll probably see coming up in the future. Yes, sir.
Hello, I'm Professor Carter, Professor of Economics Firm. I have three questions, very quick questions about speech, more general, more specific. In terms of employment in the union, in terms of the voluntary nature of employment, so when the employee doesn't like have to pay, they certainly have the option to leave and get another job, so we can address that. In terms of compelled speech for corporations, so I'm employed a corporation, they use some of my profits to lobby the government without my direction in terms of how that's lobbied. There's there. And then a final one, this won't be too specific, but in Ohio recently, there was passed a law called House Bill 6 that basically said that there's a rider on all of our electricity bills that goes to pay First Energy. First Energy is lobbying the government for this rider. I have no choice but to pay this rider. So, from general
Absolutely. Remind me the first one again. Sorry, my mind is wrapped around the third and all. Yes. So that goes back, it's called the Constitutional Conditions Doctrine. And the court held back in the 50s that the government could not condition a benefit on the surrender of First Amendment rights without satisfying scrutiny. That arguably wasn't the law for a time period. There was a famous quote by Justice Holmes that you have the right to free speech, but you don't have the right to be a policeman. And that came up with the idea that, like, hey, if you don't like having to be a Democrat to be a policeman, you don't get to be a policeman. But the court held, starting in the 1950s and consistently after that, that the government could not condition a benefit, whether it's public employment or receiving, let's say, a welfare check or anything else, on a surrender of your constitutional rights, at least without a compelling interest for so doing. And that argument came up in Janus. The other side very much argued that strongly, saying that, hey, they don't have to be an employee. And what I just said was the court's response. That, look, the last 50 years, that's what we've said as a constitutional conditions doctrine. If you want to get rid of that, you're looking at a whole other world of what the government can get away with doing. If the government could deny you any benefit to which you're not entitled as a condition of giving up one of your rights. The second question, dealing with compelled speech to a corporation. It would be a constitutional issue if the government forced it. But because a private corporation isn't the government, there's no First Amendment infringement, which actually brings up a big issue dealing with unions. Janus applies only to public sector unions. And it's not because they're public sector unions, it's because the government is forcing the employee to pay union dues. The state of Ohio is saying, you have to pay union dues, you're fired. The school district is. Janus, at least under current law, doesn't apply to private sector employees. So if General Motors says you have to pay dues to the UAW, you're fired, under current law, that isn't a First Amendment issue. Now, there is a fight over whether or not there is enough state action there under the private sector to bring in the Constitution. Because it's not only the government, it could be a state actor, someone, a private entity acting with government authority. So if somehow the government gave a corporation somehow legal power to take somebody's money, that would bring in the Constitution. But a corporation alone, you know, if you decide you want to invest in General Motors and they spend their money on lobbying, government didn't do it. So there's no First Amendment issue with that. And then the final issue was HB 6. What was the rider used for again?
It's the subsidized power plant in northern Ohio. And we're not forced energy customers here, but we're compelled to pay for energy, and they're lobbying for that right now.
So there's what's called the government speech doctrine, which it's not exactly there, but it's pretty close. The idea is the government can force you to support its speech all at once. So if the government wants to say, we're going to levy a special tax on all of you, so the state of Ohio can do an advertising campaign to say, come to the state of Ohio, it's the heart of it all. There's no First Amendment violation at all. Because the government is considered what's called government speech. The government has the right to tax you and basically spend your money however it wants. And so if the government wants to spend your money on advocacy, that doesn't harm it. Now, I don't know if the HB 6 rider is considered advocacy, but even if it was, it wouldn't be if it was a tax. If what the government's doing is considered government speech. And that actually came up in Janus. They tried to argue that, well, what the union's really doing, it's government speech. It's acting within the government. The court rejected that and said, no, a union is a private entity. It's lobbying with against the government. It's not part of it. So therefore, it doesn't fall under that government speech doctrine. But you can see just by these answers, there's all these little doctrines that keep popping up, you know, just like turrets on a castle. So.
Just to interrupt you, rider is on the utility bill, so it's not from the general fund that the government.
It doesn't matter. They could put a rider on everybody's tax saying, you know, the special tax to pay for political speech. Now, if the government, and pretty much when it is government speech, there's not a First Amendment violation. Now, arguably, some might argue you could have a discrimination violation if the government, the way it spent that money. So let's say there was a special rider to support the political speech fund, and they only gave money from the political speech fund to the Republicans and not the Democrats. The Democrats could say, well, that spending of the money, you're discriminating against us by our viewpoint. You're not giving it to us because of our political views. So arguably in the expenditure angle, you could have a discrimination argument, but you couldn't say it's compelled speech. As a taxpayer, you couldn't say, you're forcing me to support that speech. No, that's government speech. Once it's laundered through the government's hands, it's considered government money, and your free speech rights sort of die with it. Although launder is a strong word, but anyway, it's on camera now. Yes, sir, in the back. Sure, and then we'll do the gentleman behind you.
So there is a little bit of precedence for the First Amendment protecting the freedom of speech of people on in private entities. Are you familiar with the case of Marshall v. Alabama in 1946?
I believe so, but refresh my memory, make sure we're thinking this.
Yeah, sure. The story goes basically there is a Jehovah's Witness that is distributing pamphlets at a company in town. So basically the company owns all the housing for the employees, the roads, the utilities, all of that sort of stuff. And the Supreme Court ruled that essentially they were not allowed to kick out this Jehovah's Witness from distributing religious pamphlets, despite the fact that they owned the entire property. He was trespassing, but that still didn't give them the right to infringe on his First Amendment rights.
It'd be interesting to see exactly how they do it. I don't know if I've read the case. Marshall v. out, yes.
In 1946.
Yeah, I mean, I could try to guess a couple ways they may have gone. The trespass action was likely enforced through the courts, so they could have found state action there. And also the state action doctrine really didn't have teeth until the 1970s. Actually, I should say the 80s. In the 1970s, 1960s, the Warren Court was basically willing to find state action everywhere it looked. Over time, the Rehnquist Court started to really clamp down on that idea of where there was state action, where there wasn't. So I can't speak to Marshall v. Alabama. I don't know the case off the top of my head. But it makes for an interesting case to see exactly how they wound up with that result. And also, is it still good law given what's come after is they've really tightened the state action doctrine. There was a case this term dealing with state action called Halleck, and it dealt with, is a public TV station a state actor? And basically they subcontracted out running one of these public access stations, and the question was it a state actor? And the government was involved a whole lot in what it did. And eventually the government did something that the contractor didn't like, and the Supreme Court found no state action. And under the Halleck decision, it tightened the reins even more on state action, because especially the current court basically doesn't want to turn everything into a constitutional issue. They're very resistant to that, because that can create tons of issues. Like the fact that state action applies in schools brings up a whole world of issues. You know, every student discipline type thing can now become a First Amendment issue to some degree. With public employment, you know, so many run-of-the-mill employment things can suddenly become a First Amendment issue. And so the court is very reluctant since the 1980s, since the Rehnquist court, to expand state action has been contracting it generally. Yes, gentleman in the back.
So I have two questions. One dealing with compelled speech and one with the definition of speech, and both of them dealing with New York City. So currently in the city now, there's a statute which makes it a crime, I think it's misdemeanor, not probably, to misgender somebody if use the wrong pronoun. Would that be actionable under the concept of compelled speech? Second is pornography speech. Back in the 1990s, when Joe was mayor, zoning laws in Times Square shut down a number of pornographic theaters and shops based on zoning. 400 feet, 400 yards from the school. Is that, you know, would pornography speech be protected from those kind of zoning laws?
Sure, so on the first, I would say you can look at it as a restriction on speech or compelled speech, which are really two sides of the same coin. You know, the right to speak is what you say and what you don't say. So with that New York ordinance, you know, it's what's the difference between saying you must say she or you cannot say he? You know, either way, it's either a restriction or it's compelled. So I think if the government is enforcing that, if that is a criminal offense or a misdemeanor fine, you know, I don't know, at least it would trigger First Amendment scrutiny. Now it's possible it could satisfy that scrutiny. I don't know if there's been a case on that or not, but you know, First Amendment rights aren't absolute. They can serve or be permissible, they serve a compelling government interest, and there's not a least restrictive means. A lot of times remedying discrimination in some instances it's almost always considered a compelling interest. Sometimes it's considered the least restrictive one, a speech infringement. Sometimes it's not. So whether or not that particular law would satisfy or survive speech scrutiny, you know, I can't say, but I would have to imagine it would almost have to trigger that scrutiny. In terms of, is pornography speech? Yes, I think the court in a number of cases, you know, has said so, that it is protected by the First Amendment. However, when you get into zoning laws, you get a lot of time, place, manner type restrictions where the government has a much freer hand. Like if the government wants to say on the interstate highway system, we don't want a lot of billboards cluttering up these beautiful mountains, therefore no billboards. That's more of a time, place, manner restriction. It's not content-centered. And so if it's not content-centered, the government has a lot more flexibility. So I bet you Athens has all kinds of, maybe, I guess, restrictions on signs, of what kind of signs can you put up on Court Street. You might not necessarily be able to put up a giant neon sign that blinds everybody walking by it as time, place, manner. And it survives First Amendment scrutiny because it's not content-based. They're not saying you can't put up a sign if it says vote Republican, but you can if it says vote Democrat. Then you have a content restriction, then the First Amendment has a lot of teeth. But on the other hand, if you're doing it more broad-based on time and area, the government has a freer hand. And my understanding is, I'm not real familiar with that area of the law, that's how the government can get away with a lot of restrictions, you know, on pornography, that they don't want you to just open an adult bookstore next to, you know, the elementary school and have, you know, pornographic images right on the front of the building. Maybe it's speech, but they could say not there type thing. Yes, sir.
The more interesting First Amendment issues that I find fascinating is sex offense registries and First Amendment access to internet, access to social media. So I think it was January of this year before overturned the North Carolina statute that basically said if you were
I have general thoughts without knowing what I'm talking about. Let's preface that. I know that case did happen. I remember reading about it, but I actually haven't read its basis. And I couldn't tell you off the top of my head what the law is on that. But just in general, hopefully I don't misspeak on this, so don't, write this down. With respect to people who are convicted of crimes, the government has a lot more leeway on the restrictions it can put on, especially the way they justify it is, you were sentenced for 10 years, but we're letting you out a couple years early, and now here are the conditions of getting out early. And the government, through that hook, even though obviously you're restricting the individual's First Amendment rights, that becomes the government's justification for so doing, as a general matter. But again, exactly how that case was decided and exactly what the current state of litigation is over social media restrictions, I just don't know, sorry to say. Is there any other? Yes, Robert.
Can I just go back to Janus and why is that you said? So, I suspect there's an argument that said, well, look, you're a member of a public sector union. You make more money, right, probably, than you would as a private sector employee with the same set of skills, same set of jobs. You do it across. And the unions enable unions to improve the lives of their members, the whole members, right? Why is it, as a matter of law, that a free speech right would trump a right to have a liberty, right? What is it constitutionally makes this right of free speech? Not just the first, but why is that trump these other goods that I think some people recognize by public sector union activity?
Sure, and that's basically a summary of the free rider argument, that the union, what it's doing, benefits these individuals, why shouldn't they pay for it? And my answer to it was, it's up to each individual to choose what benefits them, and what they think, more importantly, is worth their money. Some people may think the union does a poor job, and it's not worth their support. Others may think, well, it does an okay job, but I'd rather spend my money on other things. And those who, of course, support it, think it's really worth my support, they would support it. But it's not the role of the government to choose whose speech is in someone's best interest. Like, just think of that in terms of a different analogy. Like, arguably, the American Dental Association, its lobbying of government may actually do great things for dentists around the nation. But should the government force all dentists to support the American Dental Association? I don't know if there's such an organization, by the way. But just something like that. You can think of a lot of examples. Should businesses be forced to support the Chamber of Commerce? Chamber of Commerce does a whole lot of lobbying to try to improve the business environment. Should businesses be required to support that speech? And I think it's a very dangerous idea when you get the government in the business of choosing, this is your advocate, this is who you support. Because besides infringing on each individual's right to choose who they support, you start to interfere with the marketplace of ideas the First Amendment protects, which is somewhat of a separate idea. But think back, what is one of the larger purposes of the First Amendment? One of which is individual rights. The idea everyone has a natural right, to choose what they think, what they believe. But the First Amendment also has a political aspect. If the government can control how people speak, the government is in effect controlling itself. And that the right to free speech without government interference is essential for the people to control the government. Once you have the government reaching out and saying, you know what, this is who is going to advocate on behalf of this group of people, this is on behalf of that group of people, the government is basically rigging the system that is designed to control the government. I mean, just think of that in terms of political parties. You see that in less than free countries. This party shall speak for everyone. That is the true advocate. The Communist Party has the workers' interests in mind. Any other party, no. The government has decided. So the government cannot have that degree of control over it. And you can see that with the public sector unions. Before you had basically the public sector unions in many states where they're powerful, the fact the government forced every public sector employee to support them made them one of the most powerful political factions in the state. And not necessarily because of voluntary support, but because the government compelled that support. Because the government can make any entity the most powerful political body in that field by making it the mandatory representative. If the state said, hey, every business has to put 2% of its money to the Ohio Chamber of Commerce. Ohio Chamber of Commerce just became one very powerful political animal. So you can't have the government interfere in that way. So it's partially for the right of each individual to choose, but also the idea of the government not interfering in the marketplace of ideas, of why it can't choose who speaks and whose speech any individual can support. Yes, Professor Vetter.
Bill, this may be slightly off topic, but being a tenured professor, I want to hear all whether it's all or not. At the beginning of this decade, I think there were 18 states in the United States which were so-called right-to-work states. I think now there are about 27.
Correct.
Is that correct? Yes. And there have been a long time prior to 2010, say between 1980 and 2010, where there was relatively modest movement in that number. It went 15, 16, Oklahoma adopted, for example, one or two. But it seemed like there was a political equilibrium at work. The people fighting to expand unionization had a lot of clout. They had forcible due payments, they had a lot of clout legislation, but they didn't have enough clout to repeal right-to-work laws, and the other side didn't have enough clout to put them in effect. Sometime after 2010, there was an upsurge in the number of right-to-work states. In the Midwest, which, no one in 2010 would have ever thought Michigan or Wisconsin would become right-to-work states. It was just unheard of, and yet it happened. Why is this happening? Well, maybe I should say, why is it happening, yet it isn't continuing? Will it continue? What is the prognosis of the future? And I know you're not a lawyer, not a political scientist, but maybe you have some thoughts on this.
Sure, absolutely. And just to explain for those unfamiliar what a right-to-work law is, it's a state law that says no one can be forced to pay union dues as a condition of employment. So in a non-right to, like put Janus aside in the First Amendment, just statutory, Ohio is not a right-to-work state. So if you went to work, say, at a unionized factory, you had to pay union dues or you're fired. On the other hand, in a right-to-work state, like let's say Virginia, they couldn't have that condition of employment. They couldn't require that you pay union dues. And for a very long period of time, as Professor Vetter said, not much changed. There was one or two different right-to-work states changed, but let's put it this way. If you were a labor lawyer in 1970 and you fell into the ice and froze, and they thawed you out in 2008, after they showed you what a computer was, you'd be right up to speed. I mean, really nothing had changed in terms of labor law, for a long period of time. And now over the last 10 years, huge amounts of fluctuation. Starting in 2010 with Wisconsin and Act 10, those are Governor Walker's reforms. And all of a sudden, you just saw a lot of change, at the state levels. And many states went right to work and also made a lot of other changes in their law. Ohio almost did the same thing with a bill called SB 6 that actually passed but was repealed in a ballot initiative. And, I'm sorry, SB 5. I'm sorry, thank you. SB 5. Sorry, you had HB 6 in my mind from earlier. And so, yeah, SB 5. And it's just a lot of dynamism. And also in the courts with Janus. Not much had changed since the boot in 1977. Then all of a sudden, starting in 2012, the Supreme Court started to relook at this area. And there were a series of cases. Janus didn't just come out of the blue like a lightning bolt. It was a series of cases that led up to Janus from 2012 eventually to 2018. So you're seeing just a lot of fluctuation and dynamism right now. What will happen next? It's always hard to make predictions about the future, the whole Yogi Berra thing. I think eventually it'll slow down. Eventually you'll hit a stasis again. But at least for the next few years, there's still a lot of dynamism. In reaction to Janus, there's been a number of state laws, they're generally called anti-Janus laws, as states have tried to do things to take some of the teeth out of Janus, basically by saying that, for example, public sector employees, if you're currently a member of the union, you can only get out during 10 days per year or 15 days per year. So basically for most of the year, you can't get out under Janus, and a variety of other things that I won't necessarily get into. Those are being challenged. There's a huge amount of litigation going on in the courts across the country concerning the follow-up to Janus. What exactly does it mean? Will this go on forever? It's tough to say. And then, of course, you could also have a reaction from the other side. The unions, some of the things they're demanding now from their political allies are much, much further down the road than what they were talking about just a decade earlier. Like, for example, before it was a very academic idea, this idea of what's called sector bargaining. Sector bargaining is the idea is you don't just unionize companies, you declare an entire sector of the economy to be unionized. And then the union bargains with industry leaders, and then whatever they set applies to the entire industry. Now, before that was very much an academic idea. All of a sudden, I'm seeing it popping up in debates, like as a real thing. That is a very large leap in another direction. Will that come to pass? Obviously, how politics play out matters. But there's just a great deal of fluctuation that continues to this day that really wasn't present, for a very long time. Yes, sir.
First, thank you so much for coming and speaking on such an important topic. One topic that tends to be popular among college students, I think, is the rise of this belief that there's such a thing as speech that can hurt someone physically or mentally, hate speech, that sort of thing. So I'd just be curious to hear kind of how that topic gets played out in courts, or how it's currently playing out.
Yeah, it is starting to push. I don't know which cases necessarily come up. You've seen it more with due process, in Title IX and things like that. I read more about this. This isn't my area, but universities setting up disciplinary procedures that arguably don't quite afford due process to which people may be entitled. So I know there's been a lot of litigation and a lot of fighting over that. When you start getting to the point of the government, or for that matter, a public university, punishing someone for speech that is arguably offensive, then you're going to start seeing these First Amendment issues coming up. Right now, it's more of the culture of being shamed, on Twitter and all the rest, but it hasn't necessarily had the teeth of government behind it. But as long as if this idea continues to spread, eventually you're going to see states and governments starting to do it. It'll probably start with city councils, that a little more left of center than perhaps other, public bodies starting to push that idea, and then you'll start seeing it reach the courts. And it'll be very interesting what the courts do with it. Because ultimately the courts, they're composed of judges who are human beings. Human beings come from society. I would think this current generation of judges, coming from very much a libertarian free speech era, wouldn't probably look very kindly upon those kind of restrictions. However, 20 years from now, as you get judges reaching the bench who sort of grew up in the social justice idea, maybe their conception of the law will change. Because ultimately, the law follows society. There's a lag. But ultimately, what's in society eventually influences the law. So how that develops is something very much to watch. I'm not aware of anything at the courts right now. Doesn't mean it's not there, but I'm not aware of it. But in the future, I think that's going to be an issue. Yes, ma'am.
So we understand that Google can't necessarily violate someone's First Amendment, but if the member of Congress were to have a press conference or something and say Google should, crack down on this group, or Google should ban would that not in the opinion, or still not
I would still say in that instance, still Google, if there's not the teeth of government. So a congressman saying they should doesn't get you to state action. You have to be using state authority, basically, some sort of power of the state, either through joint action with the state, or the state gives you a power to do something that otherwise you necessarily couldn't do. That basically makes you the magic word, term of art, is state actor. Are you a state actor? Can it be said that you are in fact acting as the arm of the state? So let's say instead of a policeman, the state hired a private bounty hunter to go arrest someone. That person is acting as an arm of the state, and therefore the constitutional protections would apply with respect to what that individual did. A congressman urging it. If the government gave Google monopoly power over, okay, Google is now the search engine, that's what you have to use, then you may have state action. But just encouraging it wouldn't be enough in the state action doctrine. No, sure. Yes, sir.
So I was wondering, how, if at all, do First Amendment rights change during wartime, or if somebody maybe has information about some matter of national security?
It comes to the compelling government interest. So the general test, it changes on some things, like restrictions that don't affect content, like where you can put a billboard, there's a lesser standard of scrutiny, but a true restriction on speech, It has to serve a compelling government interest and be the least restrictive means to meeting it. When it comes to national security, the courts will generally give the government a lot more leeway than it would otherwise have if it is truly national security. So it's really just a question of when is that test met. So even in Janus, we had to argue over scrutiny, but once we got to scrutiny, the state of Illinois and the unions didn't give up. They said, no, we satisfy it because of the free rider argument that Robert brought up earlier and a variety of other arguments. So with national security, you see that a lot. And just one thing I've personally seen that is what will happen is during a true emergency, the courts give a lot of discretion, and then sort of the political mood changes, and then all of a sudden they say, well, maybe we shouldn't have given quite as much. And then they start to take back what they gave just a little bit earlier. But the courts are very reluctant to second guess, especially because the Constitution's separation of powers gives a lot of authority to the executive, over wartime emergencies. And so the government just has a lot more discretion. But in terms of the ultimate violation, now it's interesting of what they could get away with now. During this First World War, Second World War, just straight speech restrictions. Whether they could do that now is debatable, especially without a true threat. It's not like there's very few threats to think about to say, America may end if this doesn't work out. It's more of, well, I hope we win this war, but it's not the Second World War where humanity's at stake. So what could be gotten away with is, I'd say more limited than what you'd see there in the Second World War, First World War. Yes. I believe I saw. Robert, yes.
Now I'll ask the last question. Moderator's prerogative. So there are a lot of undergrads here. A lot of some of them are freshmen, some of them are not. But a lot of them are thinking about going to law school, right? And you were 20 years ago, 22 years ago. You were leaving college and some were, let's say, years before. What advice do you have, right, for undergrads who are thinking, I want to go to law school, I want a career in law? What can they do, especially for freshmen or sophomores, to prepare themselves to do well in their careers later?
Sure. I've probably two things about law school. The first is, in terms of making the choice, think it out. Like, I have to admit that I did law school in terms of default. I was doing something and I was like, well, that didn't work out, I'll go to law school and see where that takes me. And sometimes it can work out, but it's 3 more years of school, especially if you're paying with loans and such. The legal industry has shrunk a little bit. Actually, a lot of law schools, smaller law schools are closing. The idea of getting right out of law school and being paid 150 grand is gone, unless you're coming right, top of Yale or something like that. So I would very much think through, it's no longer what it was 30 years ago where I'll just go to law school and it'll work out when I get out the other end. I would very much have a plan of, okay, I'll be a tax attorney, I'm good at accounting. And that there is a pot of gold at the end of that rainbow, I'll tell you that. But I wouldn't encourage doing it as just well, I know what I want to do with my life. I'll do 3 years of law school and see where it takes me. It could very much well work out, but don't count on the legal profession being as lucrative as it's been, because just in the last 10 years, there's been a contraction. Corporations are much more sensitive to how they bill. It's no longer a growth industry, and arguably start getting machine learning and things like that coming may shrink it even more, because you just don't need as much support staff. But now, for those of you who do want to go to law school after that ringing endorsement of going, I'd say as an undergrad, the biggest thing, don't necessarily try to learn law, English. Most of what you do as a lawyer is reading and writing, and especially writing. And that's one thing I wish I would have done. Back when I was an undergrad, if you told me I had to write a paper, the first thing is, all right, how long does it have to be? What are the margins? What are the spaces? I'm trying to think, what is the shortest thing I could possibly write? Because I didn't like doing it. And in retrospect, I wasn't a very good writer when I got out of law school. And it hurt me when I first started practicing. It took a while to actually become a better writer. I read stuff I wrote 10 years ago and I cringe. And I just think if I would have taken the time to become a better writer, because it's almost everything you do, again, unless you're a tax attorney or something very specialized, writing is what you're going to spend a huge amount of time doing. And the only way to do it is to read good literature or writing, and especially journalism. Because actually the way you write as a lawyer, the closest thing close to it is journalism. Because journalism is efficiency of words. It's very quick. Judges are very busy people. They read all day too. You have to get that across quickly, but in a relatively entertaining way. That's how journalists write. So take journalism classes just to learn how to write like that, read, and that's the thing that can prepare you. As I was just talking with this gentleman right here earlier about the LSAT, there's two parts of the LSAT. One is reading comprehension, the other is logic games. I mean, literally logic games. Like 4 people are crossing a river, one person's slower than the other, who's faster than the other person. Sally gets across first, who's third? I mean, those are the questions on the LSAT. Other than taking a basic logic class and practicing, don't take too much coursework in that. You know, it's really not about the law, it's about reading and writing, so that's what I would encourage as an undergrad, is learn how to write, and the rest will come. You know, they'll teach you in law school.